Hello, so my name is Tim Hughes. I'm an attorney with the Tennessee Alliance for Legal Services, where I run a statewide free legal helpline for low-income Tennesseans. And on January 15th, we're going to be using a spin-off of that helpline and volunteers like you to direct services and assistance to those who were impacted by the bombing in downtown Nashville. So before going any further, I do want to thank our friends at the Nashville Bar Association for suggesting this clinic and helping to put it together. So what is it? This is going to be a telephone-based legal clinic, and our outreach materials will focus on a number of main issues that we think folks downtown might be facing, including employment law, insurance claims, renters' rights, and resources that are available to them. So when is it? It's Friday, January 15th, and it's anytime you're available. So when I say that, I mean that if you can volunteer for 30 minutes, that would be great. If you can volunteer for 2 hours, that would be great too. You just let us know when you're available and we're going to put you on a calendar. And I'll let you know a little bit more about how that's going to work as we go. So how to volunteer is emailing Monica Mackey at monica.mackey@nashvillebar.org. And in doing so, please state your availability. For example, if you're available Friday from 11 to 12:30, that would be great. And please, if you'll use 30-minute increments to give enough time for each helpline call. And also in that email, if you can state your practice area, that'll help us match you up with the right types of clients. So after you do that, what happens next? TALS and the Nashville Bar Association have put together flyers and outreach materials, and we're going to notify potential callers about the clinic and encourage them to call into this telephone line from January 12th to the 14th to sign up for 30-minute Friday appointments. So if you sign up from, say, 3 o'clock to 4 o'clock on Friday, what will happen next is I will email you on Thursday afternoon and let you know who to call at 3 and who to call at 3:30. And I'll also give you the client's name, their telephone number, and a brief description of their legal issue. So as far as the call goes, please be sure to call the client at the scheduled time. The client will have worked with our intake folks to select the time, so they should be ready and expecting your call. And also, I always advise folks when they're volunteering with us to use *67 to protect your privacy. Otherwise, you might have a new pro bono client for the rest of your life. So just give you a moment with this slide. One thing to know when you're providing limited scope representation is that you do not have to do conflicts checks. All right, so I know if you're listening to this, you're all experienced attorneys, but I've been doing limited scope telephone advice for the last 7 years. So someone suggested that I maybe share a few tips about how this kind of advice can be a little different. So generally speaking, when I'm giving helpline advice, I like to give callers a little opportunity at the front of the call to kind of vent and to tell their story in their own words. I do this for a few minutes and then I ask a couple questions to kind of rein things in. And what I usually find in that time is it's a good opportunity for me as a lawyer to issue spot, and clients might have a number of issues beyond what they were actually calling about. The third point here on the slide is when I note that you're on the caller's team. That's something I try to do when I'm speaking with callers. Whether or not their legal position is strong, you know, they may be frustrated, they may have been treated by someone unfairly. So I think it's perfectly okay to sympathize with folks while you're coaching them, you know, as to whether or not they ought to hire a lawyer or take any next steps in court. And finally, I note here that I will always let folks know about any applicable deadlines or statute of limitations, and be sure to document that. So, speaking of documentation, what I'm asking from volunteers is that after you make the call, please reply to the email that I sent you to let me know whether or not you were able to reach the caller. And also in that email, if you can provide a little information as to what the caller told you and what advice you gave to the caller. And if you'd like to receive CLE credit for your pro bono time, if you can include your BPR number, as well as the amount of time you dedicated to the caller. That's something that TALS can do is my organization can submit the CLE credit for you. And since you're covered by TALS malpractice insurance while you're providing advice during this clinic, TALS will log all this information into our case management system. So that's really it. I want to thank you all for helping your fellow Nashville residents. What follows will be some substantive law training that should help us all become better prepared to advise our neighbors downtown who were impacted by the explosion. So thanks again.
All right. Hi, Nashville Bar Association members. My name is Alex Fisher. I'm an attorney at Morgan & Morgan in our Nashville office at Broadway and 8th. I'm happy to be with you this afternoon, if it's afternoon when you're watching this. So I represent policyholders against their own insurance company anytime insurance is slow, low, or says no. I know that's cheesy, but it'll help you remember it. Anytime insurance is slow, low, or says no. So those policyholders may be residential property owners, they may be tenants, they may rent a residential or commercial property, or they may be commercial property owners. But real property is what I work with day in, day out, which is why I'm here to give you this training in advance of the disaster clinic next week. Well, when you're watching this, it'll be the end of this week. So one of the questions I want to prepare you for that some of these victims of the disaster may have is, how do I interact with my insurance company? And I'll tell you my number one mantra for policyholders interacting with their insurance company is pleasant yet persistent. So despite our intense frustration with insurance companies or Comcast or anyone else we talk to on the phone who frustrates and aggrieves us when we feel like we're not getting what we need, it will not behoove you to be unkind to the people who work for your insurance company. You need to be pleasant yet persistent. And that persistent part of that means that when you're talking to policyholders, they need to know it's their job to make sure their case is moving forward. I know that may seem that might not seem logical, because they may think their claims specialist or something like that is usually the title given to the person assigned to help them get a recovery from their insurance company after damage occurs. They may think it's their claims specialist job, and while technically it is, it's the policyholder's job to make sure their claim is moving forward and that they're getting paid as quickly as possible. So what does that pleasant yet persistent look like when you're talking to policyholders? That looks like checking in with your claim specialist, either by phone or email or both, every week, or maybe 2 to 3 times a week. We don't want to rise to the level of harassment, but you want to be the squeaky wheel. That policyholder wants to make sure that they are top of mind. Another thing policyholders need to know when interacting with their own insurance company is that their insurance company has the right to ask for a lot of documentation and information related to the claim. So for a lot of the individuals we may be talking to who sustained property damage as a result of the Christmas Day explosion, that's going to be a lot of personal property, whether that's a store that needs to be inventoried or an office space. And so that's going to require a lot of documentation to show what your inventory was in your store the day before the explosion, to show, what office chairs and supplies were in your office that were damaged. So that's going to require some time and effort. And so for policyholders, they need to know that's work that they need to do, or they need to delegate to someone, whether that's someone they hire to advocate on their behalf, such as an attorney or a public adjuster. And we can talk about those in a moment, just so everyone knows what a public adjuster is in case they get asked about it by some of the people you're helping, or someone who works for their company, right? So if you're a shop owner on 2nd Avenue and you have an employee who kind of works in a flex space where they do a lot of different jobs, maybe part of that employee's job for the first quarter of 2021 is helping collate and collect the information your insurance company is asking for and giving it to them in a timely and organized manner so that they can get paid for the damage that occurred to their property on Christmas Day. And when they're communicating with their insurance company, a lot of times the question is, what do I need to document? Well, they need to document everything in writing. And here's what that means. So if you have a phone call, you don't need to record it. I have clients, I'm sure some of you do too, who like to record phone calls. That's great for them. That's not what they really need to do for purposes of advocating for themselves and their insurance claim. They can just write a quick email to themselves save it in a subfolder or save it in a folder with the rest of their company that says, talk to Sarah, our claims adjuster today. She received the inventory yesterday. We should have a response by Friday. Something that keeps it top of mind of what the status is, or they're waiting on one more thing from our shop. We need to get this to them by next Monday so they can turn it over to the person who does the inventory. In terms of other communication, so if you're mailing anything in the mail or you're emailing copies of anything, again, just include a copy to yourself, the policyholder is who I'm talking about. So if they're FedExing something, please don't FedEx only originals. Make sure that the policyholder keeps copies and keeps it pretty organized of what they've sent in. Because sometimes the claim specialist at your insurance company may change. Sometimes their organization may not be the best. And one thing you absolutely don't want to have to do is, after you've spent all this time to advocate for yourself, to give your insurance company everything they've asked for, is to then have to duplicate that work if for some reason it wasn't received or was lost or was misplaced or not given to the right person. So those are some of the questions that you may get as a volunteer at the disaster clinic about, how do I interact with my insurance company? Now, another question that may come up is, what caused the damage and how does that affect coverage? Now, obviously, we know what caused the damage. There was an explosion on Christmas morning, but what that event is called may or could affect coverage. And I know that's something that especially folks in the legal community have maybe been talking about, and it might be a question you get from someone you talk to at the volunteer clinic. So I want to talk about that a little bit. And in order to talk about that, we need to talk about insurance policies a little more broadly. So most insurance policies, commercial and residential, are what are called all perils policy. That means that all direct, accidental, physical damage to or loss of your property is covered unless it's excluded. So it's covered unless it's excluded. That's what all perils policy means. Now, the other type of policy that you could have that's really in the minority, especially I think for the commercial clients that we may be talking to who were damaged in the Christmas Day explosion, is what's called a named perils policy. So named perils means they're going to list out what's covered. Instead of saying all physical damage to or loss of your property is covered, it will say these 7 things are covered: fire, windstorm, theft, sinkhole, etc. So those are 2 types of coverage. So for clients who have all perils coverage in their insurance policy, some policies, particularly commercial policies, may have an endorsement called a terrorism exclusion. You may find this in commercial policies. Thanks to 9/11, this is something that insurance companies wrote and started sticking in a lot of their commercial policies after that happened, because they didn't want to pay for damage caused by terrorism. Now, what is terrorism? We may use that word loosely when we're talking to our friends or colleagues. News Channel 5 may use that word. Twitter may use that word in their trending hashtags to describe an event. But none of those sources, our friends and family, News Channel 5, Twitter, none of them have the ability to declare something as terrorism. And we're actually going to look to the US Treasury Department's Terrorism and Financial Intelligence Office, who makes terrorism designations. And the purpose of that is so that they can freeze assets of terrorist groups and help track down and stop in their tracks and identify terrorists. Because of the isolated nature of the incident that happened on Christmas Day in Nashville, myself and my colleagues at Morgan & Morgan don't think it's likely that the US Department of Treasury is going to designate this event as terrorism. So we don't think those terrorism exclusions in these commercial policies will be triggered. I can't predict the future. I'm just telling you what I think and my colleagues at Morgan & Morgan think. But that may come up from some of the clients that you talk to at the clinic. So I just want to give you a little information so you can talk intelligently to them about it. If the person then says, well, I want to know if I have a terrorism exclusion, I'd just like to know that. Or I need to know what the limits of my policy are for the real property, or for the personal property, or for the business personal property, or for the inventory that I was getting ready to sell in my store. I don't remember what that is. My agent told me this policy 15 years ago. I've never had to look at it since then. If a policyholder wants to know more details about what's in their policy, they need to request, and these are the magic words, a certified copy of their policy that was in effect on December 25th, 2020. They need to request this in writing. Now, in writing, that could be a letter or an email. That's fine. It doesn't have to be a letter. It could be an email. They can send that to either their claims specialist. And I'm saying the words claims specialist. It could be called something different. Each insurance company refers to that person a little differently, but a claims specialist is the person who works with the policyholder to make sure they get paid for a covered loss. It's not their agent. So their agent sells them policies. The agent has nothing to do with the claims process once they file a claim with their insurance company. And that's important to know. And most policyholders don't really know the difference. They expect their agent to be the one handling their claim, when agents' jobs are to sell people insurance, not to adjust their claims with the insurance company. So they need to send this request to their claims specialist, and hopefully within 5 to 10 days, they should receive a copy either by email or mail, and they can specify, hey, I'd like to receive this by email. Some insurance companies won't send it by email, they'll only send it by mail. If they're sending it by mail, the policyholder may want to specify where it should be sent, particularly if they have a business that no longer has an ability to accept mail because of the amount of damage it sustained on Christmas Day. What a policyholder needs to look for in a certified copy of their policy are 3 parts. There are 3 parts to an insurance policy. There's the deck sheet, there's the main form, and there are the endorsements. So the deck sheet is going to be 1 to 5 pages for a residential property, maybe closer to 10 pages for a commercial property, that says the name of the business or individual who's insured, the limits of insurance, the deductible that's applied. That's really important, especially with commercial clients, because that deductible, for me, say as a homeowner, my deductible may just be $1,000 or $2,000. For a commercial property, that deductible may be much larger. It may be $10,000, $20,000, $50,000 deductible before their insurance company starts paying for damage. So that's what the deck sheet's going to be. Up to 5 pages for residential, up to 10 pages for commercial. All the personal identifying information, just specific to you, who's covered. If you have a mortgage on the property, that'll be listed on there. All the important stuff, it'll tell you the policy period showing that was in effect at the date of loss, December 25th, 2020. The next part of the policy is a main form. It's a main part of the policy. One thing that policyholders need to be aware of, particularly commercial policyholders, because that's where it can get a little more confusing because there's more paperwork, is that they should have 2 types of insurance. They should have property insurance and liability insurance. So when they're reviewing their policy, they need to make sure they're looking at the provisions that apply to property insurance, which covers their business personal property, their inventory, and their real property if they own the building, the actual dwelling, as opposed to their liability insurance, which their liability insurance protects them if someone comes into their store on 2nd Avenue, falls down, breaks their ankle, and decides to sue their store. So that liability insurance is different, and that's really not what we're going to be looking at or considering at all for the purposes of considering and assisting them and getting coverage for the damage that occurred to their property on Christmas Day. So that's the main form. So we talked about the deck sheet, the main form, and then the last big section of an insurance policy are the endorsements. So the endorsements are going to add coverage to or take away coverage from the main form. So the main form may say, we cover everything unless it's excluded. And then some of the endorsements may be additional exclusions. Some of the endorsements may be additional coverage. So it's really important that you look at the endorsements as well as the main form. Now, these 3 things together, your deck sheet, your main form, and the endorsements for a residential property owner, or let's say a renter in an apartment downtown, we're looking at 20 to 50 or 60 pages. If you're a commercial property owner, or if you're a business who has commercial insurance on your business, we're looking at 100 to 300 pages. So if they get a document back from their claims specialist that says, here's your certified policy, and it's 5 pages for someone who lives in an apartment, or it's 20 pages for a commercial property owner, they should know right away, that's not the full policy, that's not what I'm looking for. So those are the parts of an insurance policy that a policyholder may be looking for. The claims process can take a little bit of time. I will say that most insurance carriers are pretty good about moving quickly, especially when a big disaster like this occurs. They usually bring in extra personnel from around the company to help cover the amount of claims that they're handling because of a disaster, whether it's a hurricane or a tornado or the bombing that we experienced in Nashville on Christmas Day. But the property owner needs to know that their job is to cooperate with their insurance company. They have to provide all the documentation requested of them if it exists. If they're asked for documents that don't exist, obviously they can't provide that. And just do their best to advocate for themselves, which is tough to tell someone when they're pretty shell-shocked and their world's been turned upside down. And that's why sometimes they may get to a point where it's helpful for them to have someone advocate on their behalf, which is what I do and other attorneys like me. It's also what public adjusters do. I just want to mention public adjusters because that may come up in your conversations with the clients. And you may not know what a public adjuster is. I didn't until I started practicing this type of law. So a public adjuster is not an attorney. They're a licensed professional. They're licensed in the state of Tennessee who can assist a policyholder in submitting their claim to their insurance company. So a public adjuster works on a contingency fee. In Tennessee, that contingency fee can be anywhere from 7% to I think our state caps it at 25%, which could be a pretty substantial sum. But what that public adjuster can do is help them in putting together complex inventories, help them in determining the value of the items they lost, help them in putting together all the documentation to support your statements that I had 100 of this item in my store the day of the explosion and 100 of this item and 300 of this. So public adjusters can be really helpful. Like with every profession, they're very good public adjusters. There are not as good ones. There are some that are really there to help. There are some that are looking to take advantage of the situation. So if a client talks to you, hey, someone called me, they're a public adjuster. Is that a real thing? Is that an attorney? What is it? Hopefully you have a little bit of knowledge based on this training to know it is a real thing. They should be licensed in Tennessee. They're not an attorney, so they can assist and advocate for a policyholder, but they can't make any legal representations. They can't make any interpretations of law. They obviously can't file a lawsuit on behalf of a policyholder, but they can be a really valuable ally for policyholders. So it's really up to them to use their good discretion to determine if they want a public adjuster, and if so, who they should go with. If someone does retain a public adjuster, it doesn't preclude their ability to hire an attorney later on. So you can have a public adjuster assist you as a policyholder throughout your claim up to a certain point. And then if you say, I'm still not being paid the full amount for my loss, and this is a pretty substantial difference, you can still retain an attorney to file a lawsuit against your insurance company for failing to pay you the full amount of your policy that you're owed for that loss. So hopefully this gives you some knowledge and some confidence to field questions about insurance policies by the potential clients or the clients that will be getting at the disaster clinic later this week. Again, my name is Alex Fisher. I'm an attorney at Morgan & Morgan here in the Nashville office. Please feel free to reach out to me personally if you have any questions, if I can help you in any way. My number is 629-221-6502. And you can also reach out to the Nashville Bar Association, Monica, or just Google Alex Fisher at Morgan & Morgan if you have questions I haven't covered that could assist you either at the clinic later this week or any other time. Thank you.
Hi, my name is Kerry Dietz. I am a housing and consumer attorney with the Legal Aid Society of Middle Tennessee and the Cumberlands here in our Nashville office. And I am going to talk to you today a little bit about some of the legal issues that you may be asked about around the Nashville bombing and people who lost their homes specifically. So we're going to do a little bit of a rundown on some basic landlord tenant law and some of the provisions of the law that are particularly applicable to the bombing and Nashvillians who lost their homes. And hopefully this will help you field any questions you may get at the clinic. So as we all know, dozens of Nashvillians lost their homes as a result of the bombing on Christmas Day. After they've gotten shelter and, secured help with their most immediate needs, many of them are going to be dealing with whatever legal implications come from losing their homes and trying to figure out what's next. And hopefully they will be able to access help through this clinic. So here is some information that you might need to know in order to help them. So Tennessee Landlord Tenant Law is primarily codified in the Uniform Residential Landlord Tenant Act, TCA 66-28-101 et sec. This applies to all counties in Tennessee with a population of over 75,000 based on the 2010 census. So this definitely includes Davidson County. Davidson County falls under the URLTA, and so those laws will apply. Under the URLTA, lease agreements to rent a dwelling can be written or verbal. Tenants don't have to have a written lease to be considered a tenant under the law. However, verbal agreements will generally create a month-to-month tenancy as opposed to a term like you might see with a written lease of, a year. Really important to know, tenants cannot waive protections that are given to them under the URLTA, even if the lease states that those protections are waived. So you can't contract away your rights under the URLTA, and so make sure that that all those protections are being applied, even if the lease says otherwise. So the most important provision here that I think will probably come up is the provision around casualty. Can be found at TCA 66-28-503. And under this provision, the threshold question is, can the tenant live in the home during the repairs that need to be made to get it back up to where it was before the bombing? If the tenant can, the normal laws will apply. Landlords cannot force the tenant out without going through the legal eviction process in court. But if not, as I suspect suspect will be true in many cases for people who did lose their homes from the bombing, then the URLTA casualty provision applies. Under that provision, either the landlord or the tenant can opt to terminate the lease. They have to give 14 days written notice. For the tenant, this can date back to the day the premises were vacated. Here, presumably we would be talking about December 25th. If the lease is terminated by either party, the tenant is entitled to recover any prepaid rent that they paid before having to vacate. It'll be prorated to the date that they vacated or the date that they return their keys, whichever is earliest. Here, again, it is most likely going to be the date vacated, December 25th. And they are also entitled to get their security deposit back. And the security deposit provision of URLTA can be found at TCA 66-28-301. So here is a basic rundown of the URLTA provisions on the condition of the property and repairs. Landlord has some general obligations on conditions and repairs. They have a duty to do anything that they need to do to keep the rental unit habitable and in compliance with health and building codes. Again, if a home was completely destroyed, this stuff is not going to be as critical. But if there are cases where someone's home that they were renting was, only partially damaged, this stuff might come in handy and be important. Any repair requests that a tenant has for their landlord need to be made in writing. And the landlord has an obligation to follow up and make the repair if it's an essential repair like heat or water, and the issue that has caused loss of that essential repair is something that's under the landlord's control. Then the landlord has to take care of that within 2 days. Anything else that's non-essential, it's generally going to be 14 days. So if the landlord doesn't repair, then the tenant may be able to break the lease and move. And for essential services, the tenant may be able to move and seek some relief from the landlord regarding their costs. It's important to know that in Tennessee, under Tennessee law, landlords can charge a tenant or even evict a tenant over repairs. If the tenant is behind on rent, there is no right to withhold rent in Tennessee based on repairs. Or if a tenant or their guest cause the damage, obviously that's not really going to be applicable here. Or the damages are so extensive that the landlord can't make repairs with the tenant there, which again, I anticipate is going to be the case for many of these people. So if someone is evicted, they don't opt to break their lease, but the landlord opts to break their lease, the tenant will go through the eviction process in court. The landlord has to go through that process in order to forcibly remove the tenant. The landlord has to give a notice of lease termination. How much notice usually depends on the type of agreement and the reason. Like we saw earlier with that casualty provision in the URLTA, you're talking about 14 days there. But if it's something else, then these other timeframes might apply. After that lease termination period expires, however long it is, then the landlord has to go to court to get a detainer warrant. A detainer hearing will be set, cannot be set less than 6 days after the detainer warrant is issued. The tenant will be served with the detainer warrant, and then we'll have a court date. If the landlord wins in court, the tenant has 10 days to move. If the tenant still does not move, then the landlord must get a writ of possession from the court. It's really important to remember that landlords are prohibited under Tennessee law from doing anything to try and get a tenant to move other than go through this process. This is particularly important these days while the courts are slow and sometimes not processing evictions at all. Even so, landlords are not allowed to shut off utilities, change the locks, or do anything that would force the tenant to move other than going through that court process, getting that writ of possession. So as we all know, the COVID-19 pandemic has had many implications for the court and its business. This is especially true in General Sessions Court where evictions are processed, because the nature of General Sessions Court just really doesn't lend itself to going virtual or to social distancing, quite frankly. The Nashville Sessions Courts are currently closed for most in-person hearings, including the civil dockets, which would have any evictions on them. That's pursuant to that Tennessee Supreme Court order from December 22nd last year. However, that only goes through the end of January 2021. So civil dockets could resume and begin processing evictions as soon as February 1st. These are some tips for homeowners as opposed to renters that I learned last year from some experts who were helping to educate folks who had lost their homes in the tornado. And I thought that this might also be helpful in this situation as well. You know, it is not uncommon for people to kind of swoop in after a disaster and try and make a buck. So it's really important for homeowners to be conscious about what's going on, never sign anything under pressure. If they are contracting with someone to rebuild so that they can return to their dwelling, they should be pretty picky about who they hire. It's always a good idea to research anyone who approaches you about hiring them, ask for local references, and make sure that you get as much information as you can up front before you get too deep in, and certainly don't give anybody money unless you know that you're going to be able to get in touch with them and contact them later. Here are some resources that anyone who lost their home, whether they're a tenant or a homeowner, may be able to take advantage of. The United Way here in Nashville has set up a Restore the Dream Fund that is intended to help victims of the Nashville bombing. And people can get assistance from United Way and funds through that fund by calling 211 or visiting the 211 website and putting in an inquiry. That will help connect anyone who needs help with a variety of resources, anything from emergency shelter to help finding somewhere to move to longer term. And I would encourage anyone who needs help to do that sooner rather than later. The sooner you start seeking help, the more options you're going to have. You can also call the Red Cross. It's my understanding that the Red Cross is making caseworkers available to any Nashvillians who were displaced as a result of the Nashville bombing. And so people can access that help by calling the Red Cross. So you may want to pass that information on to anyone that you are working with who needs help. One final point that I would make is that it's important to keep in mind that working with victims of a bombing is going to be a little different than probably most of your typical legal work that you do. It is important to keep in mind a trauma-informed care perspective when you're working with these people. You know, be patient, supportive, encouraging. It may take you, you know, rephrasing your question a few times or just asking it a few times before you are able to get the answer that you need from the person that you're working with. That's the sort of thing that's really common in people who have been dealing with trauma. When you're dealing with trauma, your brain just isn't working the way that it normally is, and so it can be hard to stay on task and you know, respond to questions that are asked. And I know as lawyers, we always really want specific answers to specific questions, but that's the kind of thing that you're going to need to keep in mind and be prepared for. So just be patient with folks, understand that they've just gone through a trauma, and that, you know, being displaced is really stressful on top of everything else. So be kind and patient and supportive, and, you know, don't be surprised if it takes you a little longer to get the information that you need, or to get someone situated and have the legal advice that they need to help address their issue. So thank you so much for your time. Thank you for volunteering to help out, and good luck with the clinic.